Hi, my name's Alex Bagnall. I'm the Technical Manager at Total Legal Solutions, and in this short video I'm going to be looking at Part 36 offers from a cost perspective. When we talk about Part 36 offers, of course we're talking about offers which are valid and comply with the rules. If an offer is made, which states it's made pursuant to Part 36 but it doesn't comply with the rules, then everything which I'm going to say in the next 10 minutes or so isn't going to be relevant. So a Part 36 offer has to be in writing. It has to make clear that it's made pursuant to Part 36. It has to specify a period of not less than 21 days within which the defendant will be liable for the claimant's costs in accordance with Rules 3613 or 3620 if the offer is accepted. It's got to state whether it relates to the whole of the claim or to part of it, or to an issue that arises in the claim, and if so, to which part or issue. And it has to state whether it takes into account a counterclaim. Where a defendant's making a Part 36 offer, the offer has to be to pay a single sum of money, and that sum of money has to be paid within 14 days. If the offer is to pay a sum of money in instalments or in a period which is more than 14 days, then it will not be a valid Part 36 offer. And of course, most importantly of all, a Part 36 offer has to be served. That's really important, particularly in the current climate where a lot of business is being done by email, because of course there are special rules about service of documents electronically, and those rules must be complied with, because if they're not, then the offer won't be served, and if the offer isn't served, then the offer will be deemed not to have been made. So what are the consequences where a Part 36 offer is accepted? Well, those consequences depend on the stage at which that offer is accepted. If the offer is accepted within the relevant period, so that's the 21-day period after the offer is made, then the defendant will pay the claimant's costs on the standard basis to the date of acceptance. It's important to appreciate that there's no scope for discretion there. If an offer is made and it's accepted within that relevant period, then the order for costs is deemed to have been made. In Ley and Pirelli, a very significant sum of money was claimed and a much lower amount of money was accepted through Part 36. It was argued by the defendant that because the claimant had largely failed on its claim, then the defendant was effectively the successful party, and as a result, the usual costs order, which required the defendant to pay the claimant's costs, should not be made. The court concluded that the discretion to depart from the Part 36 consequences in these circumstances simply does not arise. So what this means is that if you're acting for the defendant and the claimant makes a Part 36 offer to accept a substantially reduced sum of money, and you wish to reserve your right or your client's right to argue that a different costs order should be made, then the Part 36 offer should not be accepted within the relevant period. What can be done though is to accept the offer outside of the relevant period, even if it's one day after the relevant period has expired. Because in these circumstances, although there is a starting point, which is that the defendant will pay the claimant's costs until the expiry of the relevant period, and the offeree will pay the offeror's costs thereafter, if that outcome would be unjust, then the court has the discretion to make some other order for costs. It was confirmed by the High Court in the Pallet case that where a Part 36 offer is accepted outside of the relevant period, then costs are at large. So there is the starting point, but if it is unjust, then a different costs order can be made. It's important to appreciate that where a Part 36 offer is accepted out of time, there's no presumption that the claimant will be entitled to indemnity costs. There was a period a few years ago where lots of applications were being made for indemnity costs orders following a quirky decision of the County Court in Hull. However, the Court of Appeal in Hislop and Purd concluded that there is no such presumption. So whereas a late acceptance of a Part 36 offer can be a relevant factor when dealing with conduct and deciding whether conduct should lead to an indemnity costs order, it doesn't automatically follow that a late acceptance should result in indemnity costs. So there's no analogy between a Part 36 offer being accepted late and what happens when a claimant gets to trial and matches or betters their own offer. One of the reasons why Part 36 offers are so powerful from a claimant's point of view is because if they get to trial and manage to match or better their own Part 36 offer, then there are some significant benefits to be had. The most important is that the claimant will get their costs on the indemnity basis from the date on which the Part 36 offer expired, unless it would be unjust to do so. Another benefit for a claimant who matches or betters their own Part 36 offer at trial is the award of an additional amount. Now, the additional amounts are calculated as a percentage of damages if the claim involves money, or a percentage of costs if the claim does not involve money. When you're calculating the additional amount, don't forget to take into account interest, because that can add a substantial amount on to the level of the additional amount which is payable. The additional amount is 10% of the first £500,000 awarded, plus 5% of the second £500,000. There's nothing payable on awards over £1 million, so the maximum which can be awarded as an additional amount is £75,000. However, the presumption of indemnity costs doesn't apply where a defendant makes a Part 36 offer which a claimant doesn't beat at trial. In these circumstances, the defendant will pay the claimant's costs until the expiry of the relevant period, and the claimant will pay the defendant's costs thereafter. There's no presumption of indemnity costs, and this was confirmed by the Court of Appeal in the Shalabi case. Other than where a Part 36 offer is accepted within the relevant period, the court has discretion to depart from the costs order starting point in circumstances where that starting point would be unjust. The factors that the court has to have regard to when deciding whether the outcome would be unjust are detailed in Rule 36.17.5. It's important to note that the court has to have regard to all of the circumstances of the case, but there are also 5 specific factors, and they are the terms of the Part 36 offer, when the Part 36 offer was made, the information which was available to the parties when the Part 36 offer was made, the conduct of the parties with regard to giving or refusing to give information for the purposes of evaluating the Part 36 offer, and whether the offer was a genuine attempt to settle the proceedings. It's important to appreciate that when an application is made to disapply the usual Part 36 consequences, that there is a high threshold which has to be met. In Smith and Trafford Housing Trust, the High Court described this as being a formidable obstacle. There's lots of authorities out there which deal with the disapplication of the Part 36 consequences, and it's not possible to go through them all in this short video. But here are some of the more interesting and useful ones. In Jarley and Warrington, the High Court suggested that late Part 36 offers shouldn't necessarily carry less weight than an early Part 36 offer. That may come as a surprise, but the reason for this decision was because by the late stage in the proceedings, the parties have all of the information to which they're going to be entitled. They'll have had disclosure, witness evidence, expert reports. So by the late stage in the proceedings, the parties will be able to evaluate the strengths of an offer arguably better than if that offer was made at an early stage in the proceedings. In SG and Hewitt, the Court of Appeal disapplied the usual Part 36 consequences in a claim where it was not possible to evaluate the value of the claim based on the evidence which was available when the Part 36 offer was made. In Briggs, the Court of Appeal made it clear that in order to depart from the usual consequences, a party has to show injustice, not simply that it was difficult to predict the outcome of the litigation. The way in which a case is conducted is also relevant. Where there's been any kind of dishonesty or misleading of the court or one's opponent, or where there's been material non-disclosure of important information, this can all be relevant to the court's discretion as to whether or not to apply the usual cost consequences. And of course, the offer has to be a genuine attempt to settle. So a Part 36 offer inviting the defendant to accept 100% liability for an accident, for example, is not a genuine attempt to settle. The High Court has made it clear that a request for total capitulation will mean that the Part 36 consequences should not apply. In Yentob and Mirror Group, one of the phone hacking cases, the Court of Appeal disapplied the Part 36 consequences where the principal remedy sought was not necessarily financial. One of the other issues dealt with in JLE was the question of whether the Part 36 consequences are severable. That's to say, whether it was open to the judge to conclude that it would be unjust, for example, the 10% uplift to be applied, but not unjust for the indemnity costs award to be made. Mr. Justice Stewart concluded that in principle the consequences are severable. However, it would be an unusual case where the circumstances of the case led to a conclusion that some of the consequences were just and others were unjust. And he made it very clear that it's not open to the trial judge to disapply some of the consequences because they concluded that the effect of those consequences would be disproportionate. That would be akin to the judge saying that they disagree with the rules, and of course that's not the job of the judge. Some interesting obiter comments in JLE as well related to the percentage uplifts when the additional amount is to be awarded. There were a series of cases at around that time where the court was awarding a different amount to the 10% prescribed fee. Mr. Justice Stewart concluded that it's all or nothing. You get the 10% uplift or you get nothing. The court again cannot interfere with the level of the uplift simply because it's found to be disproportionate. I hope you found this short video useful. If you've got any questions at all about anything that we went through today, please don't hesitate to get in touch.